To go, Judge.
Pardon me?
We're good to go.
Okay. This is KCR 22211623, State versus Chad Guy Daybell. This is the time set for, on short notice, a status conference. The court would note that on Tuesday of the upcoming week, we've got a change of venue hearing set for 2 days. It's been scheduled for some time. There's been some additional filings, and in the interest of judicial efficiency and economy, I just wanted to discuss with counsel a few issues. I would note there were some filings that went into the case today by the state, a motion to sequester the jury and a response in support of the defendant's motions to change venue. Well, it was a response to, not in support of, a response to the motion to change venue. And what I want to talk about, counsel, is just basically lining out where you think we are in terms of our hearings set on October, I think it's October 5th, next Tuesday, with these latest motions. First, I'll ask Mr. Pryor, have you received the latest motions filed by the state? And if so, when did you receive those?
Judge, I received those to my email at approximately 6 o'clock last night. Unfortunately, I had some other obligations that I had to address, and I didn't get an opportunity to review those until approximately 7 o'clock this morning when I started my workday. I did have a chance to review all of those. So unfortunately, it was at 7 o'clock this morning. I can't address why the state waited until the last hour to file these things, but that they can explain that.
Okay, I guess what I'm wondering is there's a motion to sequester jury, which really is part and parcel of the issue, I think, relating to venue. Is the state intending to argue and have that heard and considered on Tuesday, or will that be scheduled for hearing on another time?
Your Honor, we would like to, and the reason why is what, with our filings, you'll see that what we've essentially laid out is, while we do believe we can pick a fair and impartial jury in Fremont County or Madison County, we're not, for purposes of avoiding appeals, we're not going to object to a change of venue, but we are asking the court to follow statutory procedure that's allowed to take that jury and bring them back to Fremont County. We have a lot of reasons to do so, and so part and parcel of that is a sequestration of the jury helps provide for the fairness of the jury trial to both sides.
Okay. With that in mind, this motion to sequester kind of does play into that. Mr. Pryor, do you have any objection to us including argument on that and hearing that on Tuesday?
I do, Judge. The court's well aware that in order to have a motion, the state is required to give me 7 days notice. So in order I have an adequate amount of time to reply, I don't consider 6 o'clock last night adequate notice for a hearing that's scheduled for next Tuesday. If the state wants to file a motion to shorten time and an order requesting the court to shorten time, I'd like to have that made as part of the record. My concern is this, Judge, is although I agree that the court has the option, and it's the option, to bring a jury in and engage in that sort of procedure, my argument is simply this, Judge, is this change of venue motion has been set for a significant amount of time, And I provided copies of my exhibits a significant amount of time ago. And then just before 3 business days, actually, 2 business days between the hearing and today, the state decides to file a 17-page response. And it's labeled with a number of things that they claim are accurate. And obviously, I strongly disagree with their assertions in that response. But to then say, oh, by the way, we're going to also bring the jury in and we want to do it this way and make argument on that point, they don't get to do that. And if the court wants to shorten time, obviously, I have to defer to the court's wisdom. But they're agreeing to a change of venue. So now the issue, it's a 2-pronged issue. The venue change, they're agreeing to change venue. At this point, the court has to decide where the case gets changed to. and what location. So my feeling is simply this, is the court can hear the evidence. I've already relayed to the court that that evidence is going to be relatively brief, assuming I don't engage and there's no issues with the evidentiary issues that I don't anticipate there being, but it should be relatively brief, less than a half a day for, I think, both sides. And at that point, if the court wants to hold off and not make a decision until they hear Mr. Wood's argument on the other matter, but to put me in a position, Judge, for a hearing that is of significant importance to everyone, and say 2 business days before the hearing, by the way, you're now going to have to spend the rest of the weekend preparing for your argument on moving it and bring juries in and from another place or another location, and I'll have to address that legal issue in a short period of time. Obviously, Mr. Wood and Ms. Blake's brief was well prepared, and it took them some time to put that together. That 17-page brief did not take a day or two to put together. They've had that for a significant amount of time. And with all due respect, everybody, Judge, it's a little bit of grandstanding, it's a little bit of game playing, and I don't appreciate it. So I am vehemently opposed.
Mr. Pryor, I think you're maybe jumping to a conclusion about game playing and grandstanding there. These things happen sometimes, and this is the reason why I've called a status conference to determine what we're doing Tuesday, basically. That's the question. So, Mr. Wood, there's been an objection on the motion to sequester, that it's not filed timely. What's your response on that in terms of when you think a hearing would be appropriate on that motion?
Well, I'd like to address these accusations that Mr. Pryor has made. As the court knows, the state has a standing objection to the way this case is proceeding. And just for purposes of the record and with all due respect to the court's prior ruling, we do not feel it's appropriate to be having a hearing that affects the trial rights of Mrs. Daybell and not have her be present. Chad Daybell has waived his right to a speedy trial. This whole hearing shouldn't be happening. Now, obviously, we'll defer to the court. That's the court's decision, and we'll follow whatever the court does. We had a hearing just last week on that issue. So quite frankly, Your Honor, we've been working on moving down the path that we feel is going to lessen appeals and which protects both the defendant's rights. Now, obviously, the court ruled against us. That's fine. That's in the court's discretion. So this idea that we've just been sitting on some position or sitting on some brief, he has no right to make that accusation. He doesn't know what he's talking about. And I feel we have the right to address that. There's no reason to come into a court proceeding and act like that. So having said that, Your Honor, I would just simply make an oral motion to shorten time. I think it's absolutely appropriate, and where it dovetails into the arguments for publicity, pretrial publicity, and publicity of and jurors being affected by the publicity, I think it's absolutely appropriate. And I do want to clarify our position. What we're saying is we're not objecting to a change of venue, but we are specific in the sense that we're asking for the jury or the judge, for the court, if they are going to change venue, to bring that jury back to this county. We've read it referred to as a partial change of venue in another case. And I'm not going to get into arguing why we think that needs to happen here. But there's no rule on when we have to file a response. And so I just disagree with Mr. Pryor saying it's a midnight filing or something to that effect. He still has plenty of time to read over it, to look at it, to go over our position. And so, yes, Your Honor, we're going to make an oral motion to shorten the time for notice on that. We would ask the court to grant that. Where it dovetails, it's not a particularly difficult argument to make or to adjust to.
Right.
Judge, quite frankly, the representation that I'm in some way absolutely wrong, I would refer to their response and where they actually commented on the evidence that's going to be presented in the jury in their response. And I can't quote which paragraph it is, but when a prosecutor starts commenting on evidence and the accuracy of the evidence as it relates to my client, if you want to talk about inappropriate, that's highly inappropriate. Now, I know this is a procedural issue, and I didn't mean to get in an argument with Mr. Wood and Ms. Blake, So I guess I'm going to stop at that point and let's do what we were supposed to do as part of this hearing.
Well, okay. Before the court then is a motion to shorten time. And that would be as to a motion that landed in case today, motion to sequester jury. The court has reviewed that motion. It's a 4-page motion. It relates directly to the issues that are part of change of venue consideration. And a couple of things I guess I'll note. We've had the change of venue hearing set for a long time. That's not going to be moved. That's next week on Tuesday. The court does find these are issues that are directly related to consideration there. To the extent you feel you may be prejudiced by not having enough time, Mr. Pryor, I'm going to allow argument on that, but I would have the option potentially to allow you some additional response time after the hearing if you think you need that, but I'll allow the state to argue this motion to sequester jury as part of the change of venue proceedings. I guess another thing I'll point out, as I read it, I'm not clear if there's any kind of a stipulation here or not to change venue. Regardless of that, the court, of course, would consider that strongly, but also has to make an independent finding as to whether or not it's appropriate to change venue. And on that issue, counsel, and I'll just give you kind of a heads up. One of the factors that's being argued that relates to a lot of these motions are the economics of, for example, bringing in jurors versus taking the trial somewhere else. And in order for me to really consider that, I'll just let you know, I'll need some data to look at. I don't know how much it could be proposed to cost to sequester jurors for an extended time versus costs of security and sheriff's fees that may be incurred if Mr. Daybell is transported to another jail and those costs are passed on to Madison and Fremont counties. So I appreciate arguments will be made on that, but I'll just let everyone know that whether that's going to be a part of the hearing on Tuesday or whether it'll need to be supplemented, I've got to be able to look at some facts if I'm going to make a determination on that. And right now I can kind of make some guesses, but they'd only be guesses. So I guess I'll just let you know that that's information I think is going to be relevant if that's where we end up going. So with that in mind, I am going to find that the response that was filed, the 18-page response brief, is timely, and that'll be fully considered. The motion to sequester, I'll grant motion to shorten time so that can be heard and argued on the Tuesday hearing. And then again, Mr. Pryor, if you feel like that's disadvantaged you because of the timeliness, I may allow additional time for a response. So we'll wrap up as much as we can on the Tuesday, Wednesday hearings, assuming it goes into the second day. And I'll allow that argument by the state.
And Judge, I would make one request that if it's Mr. Wood and Ms. Blake's position to submit economic information, I would prefer not to have that 12 hours before the hearing on Tuesday. That would be my preference, is not to drop that on me Monday night at 6 o'clock before a Tuesday hearing. Again, I want to make a record that I've been clearly disadvantaged in this regard with these 17-page briefs and this motion at such a short time. And I have a procedural problem with an oral motion to shorten time. So having made that record, thank you, Your Honor.
Okay. And I guess I'll note that there's a legal determination on, is there going to be a change of venue? And then the next step, if that is determined, to me, gets into the logistics. And I don't know that everyone can and could be prepared with logistics, because that would be largely determined on what the court says we're doing in terms of either bringing in a jury if we do that, or taking the trial somewhere else, or potentially the court finding that there's not enough of a showing to take it out of Fremont County, at which point we wouldn't need to go through any of that information. So I foresee the chance there may be a need for future submission of information after the hearing, and certainly would allow all parties an adequate opportunity to do that before we pin down the logistics of when and where this may happen.
Judge, my understanding on the pleadings from Mr. Wood and Ms. Blake is that they are agreeing to a change of venue. and I'm agreeing to a change of venue. So I think that issue is resolved. Mr. Wood and Ms. Blake, and I don't want to necessarily speak for them, desire a solution that's different from my solution. So I think,
Okay, but Mr. Pryor, I don't know that it's fully resolved. Even if you stipulate, the court still has to say, why are we doing this, and find that it complies with the statute. So there still has to be a legal determination, even if there's a stipulation.
okay,
So, and again, I may full well agree with you. I still need to hear some reasoning and facts on the record that justify that change of venue. Because of course the presumption is not to do that, but if we need to do that, the rule under 29, or I'm sorry, criminal rule 21A, I have to make a finding that I'm satisfied that a fair and impartial trial cannot be held in the county. And so just because both sides say that, I may well agree, but I want to know what that's based on. And I think that should be part of the focus of your arguments on Tuesday, if you do have an agreement on that issue.
thank you, Your Honor.
Okay. I think that probably covers what we need to in terms of the status conference for today. Counsel, let me just get your thoughts, if you may, on whether or not you think we'll be going into Wednesday on this hearing, given these latest developments. Mr. Wood, what are your thoughts on whether or not you think we could do this in a day on Tuesday?
I think we can. I mean, you never know what's going to happen in court. I guess that's why, but I think we can.
Okay, thank you. Mr. Pryor, your thoughts there?
Yeah, Judge, I anticipate, and I agree with Mr. Wood, that I anticipate that we will not go beyond the day. Frankly, I'm almost anticipating a half-day hearing is what I'm expecting.
All right, I appreciate that. And I'll just let you know that if we're going long in a day on that type of thing, my preference would be to go late versus stop and do another hour, for example, the following day. I think it's just more economical to finish it out if we need to get into the evening. So I'll alert the staff at the courthouse that there's a potential we may go late on Tuesday if necessary, and I'll just give all parties that opportunity to address that if we get near the end of the day, how you want to proceed. Okay, I think that'll be all we need to cover for this afternoon then, until we bring up more matters on Tuesday. Anything else for this morning then, Mr. Wood?
Not from the state, Your Honor.
All right, Mr. Pryor, anything further?
Not from the defense, Your Honor. Thank you.
Okay, thanks for your appearances this morning, and we'll see everybody again on Tuesday.
Thank you, Your Honor.
You're welcome. Thanks for your appearances as well.